that there was no problems with either party.
Either one. Okay. Right. Thank you. All right. Back to you.
That's my understanding as well. And so it actually can work out pretty well for him to continue to do well in school there and then transition back. And I've talked to him, when I first met him, he said, I had a gun because people do things to me. Yeah. So for protection. And unfortunately, he lives in that sort of environment. But I've tried to impress upon him that he cannot carry a weapon. And hopefully from this experience, he will be able to abstain from doing that. So we ask that you accept the plea as negotiated.
Okay, thank you. And Mr. Mender.
Same, Judge. We ask that you accept the plea as negotiated. You saw the videotape. Mr. Mender was just there. He didn't have a weapon, anything. He was just sort of there, and he got caught up in it. I don't think I'm not aware of Mr. Mender having any type of history. And I think to me, he appears to be a great kid. And I think this is probably the right resolution. And hopefully he won't be around any kids that have guns or anything. But you got to remember, Judge, this sort of started out as a misunderstanding.
It did, and it's come to light. I mean, it wasn't clear whose phone it was. Right. It has become clear whose phone it was. So, and even Mr. Horn benefited from the state's realization of how this played out. So it started as a misunderstanding. It ended with someone getting shot.
That's true. That's true. And I think it was a little more to it, but I can't prove that. Yeah. But our victim was very interested in this case. I mean, he had a previous case of his own down here in Fulton County. And when I first met my client, he indicated that the victim had said some things of a sexual nature to the kids. And so I can't prove that. That's not on video.
Right.
So,
or it's not on audio.
I think it's right. It's not on audio. I think it's an unfortunate situation. I hope Mr. Rogers learns that he's got to learn to work with his hands.
Yep.
Baseball
bat, something.
Something.
Yeah.
Well, maybe not baseball bat.
Okay. Well, not a gun.
Yeah, not a gun.
That's the key part.
Just hands.
Yeah.
And hopefully we can keep him safe. He's a bigger kid. At 14, and sometimes bigger kids get preyed upon. Just that simple. I worry about Mr. Mender. He's a smaller kid. And so these guys have to, they have to take the right steps to protect themselves. So I think these are the right resolutions, and I think the state for that.
Okay. Is there anyone here for Mr. Mender?
I'm sorry.
Okay. I recognize, it's okay. I know you're filling in, but his mom has been very interested and active in the case as well. So I appreciate you being here again. All right, Mr. Rogers, anything you want to add? You don't have to say anything at all, but it's your plea, not mine. And so if there are things you want me to know about you, about this situation, anything else, now's the time.
Sir.
Okay, same for you, Mr. Mender. Anything you want to share?
No, sir.
Okay. Ms. Singleton, how will it work for Mr. Mender's plea is one of, it sounded like what was handed to me was 2 years probation. I was confused by that, but things work differently in juvenile court because he's pleading to a misdemeanor, which of course has at most 12 months, but maybe if it's a delinquency finding or whatever is processed down in juvenile court, it can be a longer sentence than that.
Yeah.
I want to know what I'm pronouncing today for two reasons. I don't want to say something on the record that makes it difficult for juvenile court to do what everyone has been discussing. Two, just as important, it seems like Mr. Mender ought to get out right away based on this disposition because the state's asking for a probated or supervisory sentence. And so I don't want Mr. Mender stuck because I articulate things the wrong way today.
So what's going to happen to Mr. Mender's case, Your Honor, is that once the paperwork is filed into the clerk, I'll send it down to juvenile court. He'll be placed on a detention hearing calendar probably within about 5 days. At that time, they'll decide whether or not to release him.
Okay.
As far as the conditions that are listed in what would be considered an agreement suggestion by juvenile court, they will do their own screening and make a decision as whether to accept those conditions or do something less.
So this is sort of like me telling something to the Department of Corrections. They'll say that's interesting, but we'll figure out from our broader experience with participants like this, what's in the best interest of the child.
That's correct.
Okay. And I think, Ms. Davis, you submitted a proposed order.
I have, Judge. I will amend it though to 1 year though, since it is a misdemeanor.
Okay, that's fine. Could someone who is found delinquent in connection with a misdemeanor in juvenile court be given supervision that exceeds 1 year?
Not likely.
Okay,
But
all right.
they have the ability to supervise. Their supervision decisions are not just based on the charge, it's also based on the background.
Sure. Which sounds like is favorable to Mr. Mender, given that he has no background, and a mom who's active in his life, which is good. Okay. And then for Mr. Rogers, in pronouncing his sentence, and that's going to go on a standard adult disposition, so I'm familiar with that. He ought to get credit for time served from that date you mentioned, which was November 27th of 2024.
That's correct, Your Honor. And so for his sentence, the sentence will need to state that the defendant to receive credit from that exact date.
Yep.
In order for them to make the calculations. It will be day for day,
Mhm.
as the court is aware. It will also need to state that upon completion of the sentence that he be released to myself, because he will then be on probation with me. As the court is aware, the courtesy supervision until he is 17.
Right.
The sentence still lasts that long.
And because he will not be in custody, do we still have a hearing at age 17 to see what comes next? Or that's only if someone's in custody that there's I'm turning 17, what's next?
Only if they're in custody.
Okay, all right.
But I forgot to mention first offender. He's first offender eligible.
Okay, he is. Have you talked to Mr. Rogers about first offender?
Yes.
That was the conversation?
Right, we had a discussion earlier.
Okay. Mr. Rogers, I'm going to talk with you real briefly about first offender as well. You qualify for it. It's mostly an opportunity. It means if you get through this sentence with no big hiccups, then you're not a convicted felon, which is a good thing not to be at age 14. It carries a risk, though. You are young. You are still figuring out how to navigate this complicated world. And if you mess up while you are under sentence, and by mess up, I should be clear, you get arrested for something that is a felony, it's kind of serious. You're around guns again, you take something that doesn't belong to you, you've got illegal drugs. I'm not saying you do any of this, but if you do and you get arrested for it, not only will you have a new case, but you'll come back here and we'll talk about whether your first offender status should be revoked, which would mean we turn this into a conviction. And I can resentence you up to the maximum here, which would be 25 years to serve. Now, I'm not saying that's what would happen, but I am saying that if we're together again in a couple years and you got caught with a gun, I'm just using the simplest one that will get you into the most amount of trouble. You get caught with a gun, I will very likely take away first offender status, resentence you, and part of that sentence will be several years in custody. That's how toxic you and guns are going to be. But it's hard to know for sure how you're going to handle things as you grow up. Do you feel like first offender is a good idea for you, or is it a risk that you're not sure you want to take?
It's good for me.
It's good for you. Okay. Well, you are in the best position to make that choice because you see further down the road than Mr. Francis or I do right now. Okay. Well, I'm going to start with you, Mr. Rogers. I find there's a factual basis for your plea. You did have a gun on you. Someone who's 14 can't. Got to be 18 in Georgia to have a gun. You saw what happened. You didn't shoot anyone, but things got sideways between Mr. Horn and Mr. Holly. And regardless of what Mr. Holly said, getting shot's not justified. And Mr. Horn's dealing with that. He's going to be in custody for a long time. But it was your gun he was using. And you are going forward, like Mr. Francis said, need to learn how to use your mouth or your hands in terms of dealing with conflict. I do find there's a factual basis and that your plea is knowing and voluntary. Knowing means you.
All right, let's talk about that. This final segment of the hearing added depth and perspective to what was already a serious but careful courtroom proceeding involving two young defendants, Mr. Jamal Rogers and Mr. Bernard Mender. If the earlier parts laid the groundwork for plea acceptance, this part was about consequence, character, and a judge's attempt to point these young men toward a better future. And yes, there were moments of candor, compassion, and one very firm reminder that guns and youth don't mix. The judge continued his even-handed, thoughtful approach, never harsh, but always deliberate. We learned more about Mr. Rogers, including how he initially explained carrying a weapon for protection, growing up in a tough environment. His attorney, Mr. Francis, echoed that while emphasizing that Mr. Rogers has shown growth during his time in juvenile custody and is academically stable, there was a real attempt here not just to process a plea, but to counsel a young person in front of the court. The judge used language that was firm, but not condemning, advising Mr. Rogers that he needs to learn to work with his hands, not weapons. And while the maybe not a baseball bat quip brought a moment of lightness, it was underscored by a serious message. Handle your conflicts without violence. Mr. Mender's situation was handled with equal care. The court acknowledged he had no weapon, no criminal history, and no active role in the shooting. He was just there, caught in the wrong place at the wrong time. Still, the judge didn't minimize the danger of that position. The state is transferring his case to juvenile court, and there's hope he'll be released soon with a supervision plan shaped by that court. It's clear that Mr. Mender's background and his mother's engagement in the case weighed heavily in his favor. Again, the court leaned on hope, but didn't let go of accountability. There was also a small but poignant exchange about the victim's role and behavior. Allegations that the victim may have made inappropriate remarks were acknowledged, but without evidence on video or audio, they couldn't sway the legal outcome. As the judge put it, the shooting wasn't justified, no matter what was said. One of the most sobering moments came when the judge spoke directly to Mr. Rogers about first offender statusa legal lifeline that allows a felony plea to be wiped from record if the person stays clean. The judge made sure Rogers understood the stakes. If he stays out of trouble, he avoids being labeled a convicted felon. But if he slips up, particularly with another weapon, he could face resentencing up to 25 years. It was a clear, direct warning framed as an opportunity, not a threat. So how did it end? The court accepted the pleas. Mr. Rogers got credit for time served and will remain under the Department of Juvenile Justice through November, with probation and oversight from juvenile services afterward. Mr. Mender's case will move to juvenile court, with conditions still pending. Neither young man had much to say at the end, but maybe that's because this time the courtroom had already said enough. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.